rivers don't usually appear in court, but in 1970s, Hungary and Czechoslovakia promised each other a joint future in a treaty for a common project to tame and dam the Danube River. A decade later, one side walked away. The other built some of it alone and diverted the waters from the neighbor's territory. The Danube became the stage of a trial that starts about dams and electricity and ends up touching questions of whether treaties outlive politics and whether the protection of ecosystems is optional or an international obligation. Welcome to International Law Unboxed, the podcast where we unpack legal concepts from legislation and case law and make them usable in the real world. I'm your host, Leonel Lisboa. This is Modern Echoes of International Justice, our 10-episode series on how decisions of the International Court of Justice shape legal thinking on sustainability, business, and human rights. Episode 4, Damming a River, the Gabčíkovo Nagymaros Case. I think this case is so interesting because it is set at a historical period when two communist countries were transitioning into a new era, and also because it deals with the fate of a river and of millions of humans and other animals in the ecosystems of the region. To be honest, after trying different structures, I decided to start this episode with a simplified timeline of the main events. So follow me as we speedrun over 2 decades to understand what this case is about and which historical circumstances are at play. A simplified map and a detailed timeline are also available in the link in the show notes. So, the Danube River crosses many countries in Europe, and part of the border between Hungary and then Czechoslovakia, today Slovakia, has been drawn considering the course of the river. In 1977, Hungary and Czechoslovakia, both communist states at that time, signed a treaty for a joint project consisting of a system of dams and locks and power plants to generate electricity, control floods, and improve navigation along the Danube. That project and treaty, and also this case, takes the name of 2 towns, one in Czechoslovakia called Gabčíkovo and one in Hungary called Nagymaros. And from the beginning, I want to apologize for probably butchering the pronunciations since I don't speak neither Czech nor Hungarian, but I'm trying my best. So, the 2 countries signed the treaty in 1977, and during the 80s, Hungary faced economic crisis, political protests, and mounting ecological concerns. The civil movements got increasingly active in the late communist years, and they protested against the project. Then in 1989, Hungary underwent a regime change, ending 4 decades of communist rule. A new government took over, more open to environmental activism and public opinion, and that same year, Hungary suspended construction at Nagymaros and soon abandoned the project. At the same time, in 1989 and 1990, Czechoslovakia was also going through its own political transformation during the so-called Velvet Revolution, a peaceful transition from communism. In 1992, Hungary formally declares that the 1977 treaty was terminated, citing ecological necessity and fundamental change of circumstances. Czechoslovakia rejected this argument and, as a countermeasure, unilaterally implemented Variant C, diverting approximately 90% of the volume of the Danube River into a new channel entirely in its own territory. In 1993, during the so-called Velvet Divorce, Czechoslovakia split into Czech Republic and Slovakia. For many reasons, but predominantly the territorial one, Slovakia became the legal successor of Czechoslovakia regarding both the project and the dispute. That same year, Hungary and Slovakia signed a special agreement to submit the conflict to the International Court of Justice. Yes, you heard it right. Both countries agreed that they had a dispute and that they needed the help from an external organ to reach some justice and legal clarity. The formal name of this case is then the Case Concerning Gabčíkovo Nagymaros Project, Hungary versus Slovakia, 1997. But we call it just Gabčíkovo Nagymaros Case. Now that you have a timeline in mind, let's take a look at the main legal questions of the case. So Hungary wanted the court to recognize that it had the right to suspend and then terminate the 1977 treaty. In Hungary's view, the ecological necessity and fundamental change of circumstances gave it the legal right to walk away, as if the treaty had died. Slovakia, on the other hand, argued that Hungary had broken its promises under the treaty and that Slovakia had the right to respond by carrying out Variant C unilaterally. From Slovakia's perspective, this was a lawful countermeasure to protect its own rights. I know you got it, right? But countermeasures are, as you guessed it, measures that a state takes to counter an unlawful act and its consequences that comes from another state. In this case, Slovakia interpreted that when Hungary gave up the project and just walked away, Hungary violated their deal for a joint project, and therefore Slovakia had the right to put a countermeasure in place and decided that building Variant C unilaterally was the way to go. So, at the core, the court had to answer these four main questions. 1. Was the 1977 treaty still in force, or was it terminated? 2. Was Hungary justified in suspending, abandoning, and later declaring terminated the treaty? 3. Was Slovakia justified in unilaterally implementing Variant C as a countermeasure? And 4, and most importantly, how should international law reconcile the stability of treaties with the growing weight of new environmental obligations? Let's take a look at how the court decided. In 1997, the ICJ delivered this judgment after several years of proceeding, and the decision is a mix of clarity and compromise. First, the court reaffirmed the principle of pacta sunt servanda, Latin for literally saying pacts must be served or must be respected. The 1977 treaty was still in force. Hungary could not unilaterally walk away just because politics had changed or because of ecological concerns. Second, the court held that Hungary had not been justified in suspending and later terminating the treaty. The defense of necessity did not apply here. The risk to the environment was not sufficiently grave and imminent to excuse breaking international obligations. Third, the court also found that Slovakia was not justified in unilaterally building Variant C. That was not a lawful countermeasure, but a breach of the treaty. Finally, the court emphasized that both states had the obligation to return to negotiations and urged them to adapt the project in good faith to the new environmental norms of international law, including the principle of sustainable development. In short, Hungary was wrong, Slovakia was also wrong, but the treaty lived on, and both countries had to cooperate to manage their common resources and adapt to new environmental standards. Okay, now you know the facts and the decision of the court. Let's now break down and understand the main legal contributions of this case to international law in concepts that are presently very useful. The main legal contributions. Well, there are mainly three very important contributions to international law in this case. First is reaffirming Pacta Sunt Servanda, second is on sustainable development, and third is on the equitable and reasonable use of shared resources. So why is it important that the court said that Pacta Sunt Servanda? One of the arguments from Hungary is that there had been fundamental change of circumstances since the treaty was signed. The argument is that the switch from communism towards a liberal democracy, with values shifting towards more popular participation in decision making and more ecological concerns, was so monumental that the treaty had no more the power to bind Hungary. Evoking Article 62 of the Vienna Convention on the Law of Treaties, Hungary argued that circumstances had changed drastically and in an unforeseen, unpredictable manner. In spirit, the argument is something like, me as Hungary, I have changed so much that I would have never signed that treaty. Therefore, it should not apply to me. However, as the court decided, the rule in Article 62 of the Vienna Convention on the Law of Treaties cannot rescue Hungary. The changes in political and economic regimes in Hungary were deep, yes, but this is not relevant for the treaty. The treaty is about managing a river, building canals, dams, and power plants. Article 62, letter B of the Convention is clear to say that the circumstances that have changed must have been the essential basis for celebrating the treaty, which is not the case here. The other argument from Hungary is that the scientific knowledge on ecological impacts had evolved to a point of fundamental change of circumstances. But the court refused also that argument. As you can read in paragraph 104 of the decision, and I quote in relevant part, the court does not consider that new developments in the state of environmental knowledge or environmental law can be said to have been completely unforeseen. End of quote. What the court is saying here is that as time passes, we learn more about science and ecology, and that is not unexpected. On the contrary, when a treaty is signed, of course, some circumstances will continue changing, including knowledge. But just understanding more of the impacts of a project on the river and the ecosystems was not reason for Hungary to skip the obligations to negotiate a solution with a partner and just walk away. The new values and knowledge could have been used in negotiations to change the project, but not as an argument to consider that there was no more treaty. So that is Pacta Sunt Servanda. Treaties are legal rules. Legal rules exist precisely because things change, motivations change, political ideology change, but the law can only be changed in very specific ways. Unless in very, very specific exceptions, only a new agreement can change a past treaty. Now, let's jump to the considerations about sustainable development. This was the very first time that the International Court of Justice explicitly used the concept of sustainable development in a reasoning. The ICJ starts by mentioning its own precedent from the nuclear weapons opinion, you might remember from episode 2. The court explained that the environment is not an abstraction, but the living space, the quality of life, and the very health of human beings and future generations. You see, advisory opinions do matter a lot. The precedent from there is being applied in this case. Moreover, in paragraph 140 of the decision, the court defines sustainable development as this need to reconcile economic development with protection of the environment. In the same paragraph, the court explains, and I quote in relevant part, in the field of environmental protection, vigilance and prevention are required on account of the often irreversible character of the damage to the environment and of the limitations inherent to the very mechanisms of reparation of this kind of damage. End of quote. The court then reasons that as we understand more about environmental impacts that we might cause, we need to take more measures to protect the environment from those impacts, being vigilant and preventive. Applying this reasoning to the case, the court clarifies that Hungary and Slovakia had the obligation to renegotiate the terms between them in order to protect the environment, exactly the opposite of what they did. Hungary just decided to remove itself from the obligations in the treaty, and in response, Slovakia decided to go forward and move the river away from its previous course into its own territory. And this brings us to a final main legal contribution of this decision, the consideration on shared resources. When Slovakia decided to move forward on its own with the variant C of the project, it built the Gabčíkovo power plant and the Čunovo dam and canal and diverted approximately 90% of the Danube River away from the Hungarian territory. Slovakia based that decision on its own interests of using the river that both countries had expressed in the treaty, but Slovakia did something else. It decided that the correct way to compensate or punish Hungary for failing to do its part was to go ahead with this variant, which meant taking away most of the Danube River away from Hungary into its own territory. The court highlighted that this was not a proportionate measure and that it was wrong in itself. As you can read in paragraph 78, and I quote in relevant part, in putting variant C into operation, Slovakia committed an internationally wrongful act. End of quote. In paragraph 85, the court clarified, and I quote in relevant part, that by unilaterally assuming control of a shared resource and thereby depriving Hungary of its rights to equitable and reasonable share of the natural resources of the Danube, Slovakia failed to respect the proportionality which is required by international law. With this, the court confirmed that shared resources like border rivers must be dealt with in an equitable and reasonable manner, and that countermeasures must be limited by proportionality. And this brings us to the loopholes of the day. Loopholes of the day: necessity and countermeasures. So let's take a closer look at the two escape hatches that Hungary and Slovakia tried to use. The first loophole was the one that Hungary tried to use: environmental necessity. As explained in episode 2, in legal terms, necessity is interpreted very literally. Necessary is what must be. In this case, Hungary claimed that the risks to drinking water, ecosystems, and human health were so serious that it had no choice but to suspend and abandon the project. Hungary couldn't even engage in negotiations. It was necessary to leave the project entirely. The court was not convinced, as you know. Yes, the excuse of necessity exists in international law, but it is exceptional. To succeed, this excuse must meet three requirements. First, something must be at grave and imminent danger. Second, there must be no other lawful way to protect that thing that is in danger. And third, the act in necessity cannot create serious damages to the rights of other states. The Hungarian argument fails on all three. The risks were real, but not imminent enough. And even if they were, Hungary still had another option: to negotiate with its partner with care to avoid serious damage to the environment and to Slovakia's plans. I do recognize that environmental necessity is a very seducing argument. Just by putting environmental as an adjective to necessity, it already attracts sympathy from many people. But we must go beyond the appearance of the arguments and that is what the court did by rejecting this Hungarian argument. Now let's take a look at the second loophole of the day, excessive countermeasures. So in this case, Slovakia argued that when Hungary abandoned the treaty, it committed a wrongful act. Because of this, Slovakia had the right to go ahead and build variant C to enforce its rights. Now, if you want a good definition of countermeasures, you should surely check the draft articles on state responsibility from 2001 by the International Law Commission. We'll take a look at them in a future episode. But in short, imagine an international treaty as a contract between two companies. Well, if one company has to supply the other with, let's say, car parts, and then it cannot deliver on the agreed time and gets delayed, most probably the other company will impose a fee or pay a lower price to compensate for the damage that it suffered because of the delay. With a good contract and good contract law, the companies don't even need to go to court. They can directly just impose a proportionate damage to the other to rebalance stuff and carry on. I know the legal details here are different, but it's just an example and it's very useful in its similarities. If two countries agree to a joint construction project and one invests a lot and builds stuff and then the other just starts lagging and then abandons the project, it seems fair that the party that's still interested in the project continues it, right? And more, if the delays and lack of participation of the reluctant partner cause some damage with the budget and the phases planned, it seems also right that the other one could then cause some corresponding damage. Doesn't it? Of course it does. This is what we call a countermeasure. But there are conditions. Countermeasures must be directed at the wrongdoing state. They must be proportionate, and they must seek to restore the cooperation, not destroy it. These arguments cannot support variant C. Diverting approximately 90% of the Danube into Slovak territory was way disproportionate. It deprived Hungary of its share of the river and escalated the conflict instead of solving it. Slovakia had the right to a countermeasure, but by exceeding the limits of proportionality in that right, it actually violated international law. It's not because you have the right to do something that you can do anything. So, here are the loopholes of the day. You can try to get away with necessity, but you really need to prove all the requirements. And states can actually use measures to cause some pain to the other state, but they gotta do it proportionately, and they must do so with the goal of resuming cooperation, not killing it. At this point, my cat Fumasa flickered her tail and gave me a look as if saying, "Why are you humans fighting over a river? Can't you just share the water?" Well, Fumasa, you are right. But at the same time, rivers are not just water. They are also sources of power and prosperity. With dams, they produce renewable electricity. With locks, they carry cargo ships and open trade routes. They irrigate fields for agriculture, supply cities, and sometimes even mark political borders. So, sharing a river is very challenging. You need to share the benefits, responsibilities, and sometimes the sacrifices. This is why the court emphasized that common resources like the Danube must be used in an equitable and reasonable way. And here is the thread to chase. The idea doesn't stop at rivers. International law uses the same reasoning for the global commons, the areas that belong to all humanity. The high seas must be open to all states. The deep seabed is the common heritage of humanity. Antarctica is reserved for peaceful and scientific purposes. And even the outer space has to be explored for the benefit of all countries. And yes, outer space also includes your friend, the moon. Fumaça took a moment to process. Maybe thinking about her friend, the moon. Or maybe thinking about how the new technological push for space exploration and exploitation will probably put tremendous challenge to these ideas. Then she slowly blinked at me and got back to her nap. So this was episode 4, where we analyzed the Gabčíkovo Nagymaros case. But wait, you might be asking yourself, did the project advance or completely stop? What happened to the Danube? Was it restored? Is it in its previous place? Since the judgment, the two states have engaged in long negotiations, sometimes trying to cooperate, sometimes just back to quarreling. The Nagymaros Dam in Hungary was never built. On the Slovak side, the Gabčíkovo is in full operation now in 2025. The diversion channel and the Čunovo Dam remain in operation. And as a consequence, the river waters mostly flow through the artificial canal, leaving stretches of the old Danube with very reduced levels of water and ecological stress. The concerns over the environment and the energy supply have been pulling in different directions, and this tension can be felt not only in this case, but in many, many places around the world. I think that there are two main messages of this whole story. One, that tensions between the protection of the environment and the economic development are one of the marks of our days. And this means that any business project must from the very beginning consider well its impacts on people and on the environment. Otherwise, projects might only get half built and become a source of problems for many. 2. That treaties outlive politics, that international obligations to cooperate don't just disappear after domestic political changes. And we must remember that and hold the ones in power accountable to it. Otherwise, the problems that need cooperation, like climate crisis, environmental degradation, and poverty, will never be solved. Before we go, some reading recommendations. So for this case, I would like to recommend one article and one book chapter. The article is by Christina Bilder, published in 2022 in the Hungarian Yearbook of International Law and European Law, under the title The 25th Anniversary of Gabčíkovo Nagymaros Case, The Potential and Limits of International Law in Environmental Protection. It looks back at the judgment 25 years later and asks what the court really achieved and what limits it still faced in protecting the environment. And if you want a more comprehensive read, I recommend Principles of International Law Relating to Sustainable Development in Treaty and in Practice by Marie-Claire Cordonnier-Saguer and Domilola Olawoyi. It is the chapter 4 of the book Sustainable Development Law, Principles, Practices, and Prospects, published in 2025 by the Oxford University Press. It is a recent study on how states are applying sustainable development, showing how the idea continues to grow after cases like Gabčíkovo Nagymaros. Thank you for listening. If you have any questions, suggestions, or ideas, please just leave a comment in your podcast player. You can also reach out to me using social media or even email. The details and also the transcripts are in the show notes. Next episode, we analyze an advisory opinion about walls and military occupation. Join us, won't you?